Bigamy is an offense which keeps one person from legally marrying more than one other person. According to the Texas Penal Code, a person commits bigamy if, while legally married, he or she marries a person other than his or her spouse, or lives with a person other than his or her spouse under the appearance of being married. The offense is also committed if a person knows a married person other than his or her spouse is married and marries them or lives with them under the appearance of being married. Now, depending upon how you interpret this statute, you might come to the conclusion that parts of it make cohabitation and a few other circumstances that are common in society, such as a spouse living with a new partner before a divorce is final, illegal. Keep in mind, however, it would likely be very difficult for a prosecutor to get a judge or jury to convict someone in a court of law for situations that occur frequently, such as simple cohabitation. So much so that the prosecutor would be unlikely to accept charges for such an instance. When there is a higher level of deception present, however, such as someone legally marrying another person while still being legally married to someone else, charges are probably much more likely, particularly if the person has gained some sort of benefit by being legally married to two different people at the same time. According to the Penal Code, it is a defense to prosecution if the actor had a reasonable belief of death, divorce, or annulment substantiated by a certified or signed document. Bigamy, when committed against a victim 16 or younger, is a felony of the first degree. When committed against a victim 17 or older, it is a felony of the second degree. All other offenses are felonies of the third degree. Incestuous sexual relationships between immediate adult family members and young children are illegal under several offenses in Chapter 22 of the Texas Penal Code. Sexual relationships between certain adult family members are illegal under Chapter 25 and the Texas Penal Code offense of prohibited sexual conduct. According to the Penal Code, a person who engages in sexual or deviant sexual intercourse with an ancestor by descendant, blood, or adoption, a current or former stepchild or stepparent, an aunt or uncle of whole or half blood or by adoption, brother or sister, nieces, nephews, or cousins has committed prohibited sexual conduct. This chart makes it a little bit easier to visualize the offense of prohibited sexual conduct. The actor is represented by this figure. His spouse is the green figure. It is, of course, legal for him to have intercourse or deviant sexual intercourse with his spouse. If the defendant engages in sexual or deviant sexual intercourse with an ancestor by descendant, blood, or adoption, a current or former stepchild or stepparent, an aunt or uncle of whole or half blood or by adoption, a brother or sister, nieces or nephews, or cousins, he has committed prohibited sexual conduct. Keep in mind, if he engages in sexual or deviant sexual conduct with a son, daughter, niece, or nephew who is a child, this may rise to the offense of sexual assault or aggravated sexual assault in Penal Code Chapter 22. It is not illegal in the Penal Code for the actor to have intercourse or deviant sexual intercourse with his aunt or uncle by marriage, his brother-in-law or sister-in-law, or his cousin's wife, but it might make for awkward family get-togethers. A person who commits prohibited sexual conduct with an ancestor by descendant, blood, or adoption has committed a felony of the second degree. All other offenses are felonies of the third degree. The Texas Penal Code offense of agreement to abduct from custody involves a person taking a child from another person who has possession of the child under a court order. According to the Texas Penal Code, a person commits this offense if they agree, for remuneration or promise, to abduct a child younger than 18 by force, threat, misrepresentation, stealth, or unlawful entry, and knowing the child is in lawful custody under a court order. So a key element here is the child is in the other's custody pursuant to a lawful court order. All offenses under this section are state jail felonies. When we hear the word enticement, our first thought might be of a sexual offense. This might be the case, but the Texas Penal Code offense of enticing a child might also be applicable to, for instance, a biological parent who has had their parental rights terminated by a court trying to lure their biological child away from his or her lawful and appointed guardians. According to the Penal Code, a person commits this offense when, with intent to interfere with lawful custody of a child younger than 18, the person knowingly entices, persuades, or takes the child from lawful custody. If the person intended to commit a felony against the child, the offense is a felony of the third degree. All other offenses are B misdemeanors. An order by a judge to pay child support is a civil order. However, the Texas Penal Code statute of criminal non-support makes it a criminal offense not to pay. According to the Penal Code, a person commits criminal non-support if he or she intentionally or knowingly fails to provide child support for a child younger than 18, subject to a court order. Conviction can be based solely on uncorroborated testimony. It is an affirmative defense if the actor could not provide for support of the child. All offenses under the statute are state jail felonies. It's important to note criminal non-support is likely to be an offense reported to and investigated by the Texas Attorney General's office, rather than a local law enforcement agency. Upon investigation, a warrant for criminal non-support may be issued when all other means of enforcing child support have been exhausted. See the Texas Attorney General's website for more information. It is important to note that, in general, child custody falls into the realm of civil law. There are very specific and precise circumstances, however, when a person who interferes with child custody commits a criminal offense under the Texas Penal Code. Sometimes, when children are involved in a divorce proceeding, the family law judge will issue a court order decreeing the amount of time each parent is allowed to spend with a child or children, the days of the month when this will occur, and the time of day when former partners or spouses will exchange the child or children. Other times, these same sort of arrangements will be drafted without a judge by each of the soon-to-be ex-spouse's attorneys as an interim agreement between the two. One of the most difficult times, however, is the period of time between when two spouses or partners decide to get a divorce and when the judge issues the final court order outlining child custody. During this time, both parents retain their parental rights to the child, but due to hostility and resentment, may have a difficult time agreeing on who gets the child, when he or she gets them, and for how long. In addition, after a child custody court order is issued, simply failing to abide by it to the letter, for instance, being a few minutes or even hours late to exchange a child with a former spouse, is unlikely to rise to the level of a criminal offense, except under specific circumstances. First, according to the Texas Penal Code, the offense of interference with child custody must involve a child younger than 18. Next, this offense is committed when a person takes or retains a child younger than 18, when doing so violates a judgment or court order, or prior to adjudication of custody, that is, prior to the judge issuing the child custody order, and takes the child outside of the court's jurisdiction. The removal from the court's jurisdiction must be accompanied by an intent to deprive the court authority over a child. So, for instance, an intent to leave and never come back, or to be outside of the U.S. with the intent to deprive another of lawful custody or access, or by means of a non-custodial parent, so a parent who a court has determined is not entitled to lawful custody of a child, enticing the child to leave lawful custody of someone who has lawful custody. There are several caveats to this offense. First, it is a defense to prosecution if the actor returns the child to the court's jurisdiction within 3 days. Next, it is an affirmative defense to taking a child outside of the U.S. if it was pursuant to a valid court order or was due to circumstances beyond the actor's control, and he or she promptly provided notice to the other person of those circumstances. Finally, the statute does not apply if the actor was entitled access to the child and was fleeing an offense of family violence. All interference with child custody offenses are state jail felonies. The Texas Penal Code offense of harboring a runaway child might sound like something out of an action movie. However, it might apply to more situations than you might realize at first thought. According to the Texas Penal Code, a person commits this offense if they knowingly harbor a runaway child who is younger than 18 and has either escaped from lawful custody of a government entity or is voluntarily absent from the child's home without consent of the parent or guardian for a substantial length of time or without intent to return. While escapes from juvenile detention facilities are fairly rare, teenage runaway situations are very frequent. Common situations where this offense may come into play are a juvenile who is a ward of the state, who walks away from a Child Protective Services facility and is harbored by an older friend or acquaintance who is aware the juvenile is supposed to be in state custody. Another situation might be where a juvenile, for instance a 16-year-old, runs away from home without consent of her parent or guardian and is harbored by her 17-year-old boyfriend, who knows she is absent from home against her parents' wishes. It is a defense to prosecution if the actor is a close relative of the child or the actor notified law enforcement or a parent within 24 hours. All offenses under this statute are A misdemeanors. The criminal offense of violation of protective order preventing offense caused by bias or prejudice is somewhat similar to its counterpart, which covers family violence, child abuse or neglect, sexual abuse and assault, indecent assault, stalking, and trafficking of persons. Unlike its family violence counterpart, however, this offense applies only to hate crime protective orders issued under the Code of Criminal Procedure. Under the Penal Code, a person commits an offense if they, in violation of a protective order, knowingly or intentionally commit an offense against persons located under Title V of the Penal Code, so for instance, assault or aggravated assault, or the offenses of arson, criminal mischief, or graffiti because of bias or prejudice. This offense is also committed if the person communicates with the protected individual directly or through another person, so indirectly, in any way if prohibited by the order in a threatening or harassing manner. Finally, a person commits this offense if they go to or near the residence or place of employment of the protected individual in violation of the protective order. The protected person, in other words, the person whom the order protects, may not be arrested for a violation of the order. 2 or more convictions of this offense is a felony of the 3rd degree. If the offense is committed by assaulting the protected person, it is also a felony of the 3rd degree. Finally, all other offenses are A misdemeanors. This offense is titled repeated violation of certain court orders or conditions of bond in a family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. As we have seen, the state of Texas has extensive laws and procedures to protect victims of family violence, child abuse and neglect, sexual assault and abuse, indecent assault, stalking, and human trafficking. A defendant who continues to harass, torment, or stalk their victim, even after an initial arrest for violating a protective order, faces very little benefit of the doubt from statutory law in the Penal Code. A person commits repeated violation of certain court orders or conditions of bond in a family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case if he or she, during a period that is 12 months or less in duration, engages in conduct described under Penal Code 25.07, which is essentially family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking, and does these 2 or more times. So a person who violates an order or conditions of bond by committing family violence in July and violates an order by committing stalking in December has committed this offense. Another example is if a defendant violated his or her bond by going near the protected person's residence in January and then violated his or her bond again by possessing a firearm in December. That 12-month period does not have to be a calendar year. The offense is committed if 2 or more violations occur within any 12-month period. Take note, most statutes require an actor to be previously convicted before an offense can be enhanced for committing the same crime twice. This statute merely states, engages in conduct. In some jurisdictions, this may be interpreted to mean simply an arrest for this behavior, regardless of whether or not the defendant was convicted or the case was dismissed. All offenses under the statute are felonies of the 3rd degree. The Texas Penal Code offense of continuous violence against the family recognizes that repeated acts of family violence can have a devastating cumulative effect on both victims and child witnesses over time. According to the Penal Code, a person commits this offense if, during a period that is 12 months or less in duration, the person 2 or more times intentionally, knowingly, or recklessly causes bodily injury to another person with which the actor has or had a dating, family, or household relationship. So a defendant who assaults his spouse in January and causes her bodily injury and then does it again within 12 months, say September, may be charged with continuous violence against the family following the second offense. Criteria exist for joining offenses and counts. In general, all offenses under the statute are felonies of the third degree. So in our example, each offense of assault causing bodily injury by itself would be 2A misdemeanors. But together, under continuous violence against the family, they are a felony of the third degree. Finally, the Penal Code specifies that if a jury is the trier of fact, the jury need not unanimously agree on the specific dates or incidents that constitute the two or more times. They need only agree on the county, in other words, the jurisdiction, and that the defendant committed conduct qualifying for this offense 2 or more times within 12 months. This criminal offense is officially titled violation of certain court orders or conditions of bond in a family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. So remember what we learned from the Code of Criminal Procedure. A protective order is very different from a restraining order. A restraining order is a civil order which is not criminally enforceable and may be issued for anyone or almost any action as part of a civil lawsuit. There is no criminal offense in the Penal Code for violating a restraining order. A protective order, on the other hand, is a civil order which is criminally enforceable. So is an emergency protection order. A violation of a protective order or emergency protection order requires a police response and imposes criminal penalties, including jail time, on someone like a family violence abuser if he takes an action which a judge has forbidden him to do. So once again, none of what we are talking about with this criminal offense applies in any way to a restraining order. Only protective orders and emergency protection orders, and there is one other way. In addition to violating a protective order or emergency protection order, a person can commit a criminal offense found in Chapter 25 of the Penal Code. A defendant can also violate conditions of bond in relation to a family violence, child abuse or neglect, sexual assault or abuse, stalking, or trafficking case. Note, there's 8 offenses depicted on conditions of bond which can serve as the original charge or arrest from which the bond originated, but because the title of the offense includes sexual assault or sexual abuse, there could potentially be many more depending on how you interpret the term abuse. Conditions of bond are sort of similar to protective orders and are another way to protect a victim while a criminal case is waiting to go to trial. This is how conditions of bond typically work. A defendant is arrested following a criminal offense such as family violence or stalking. Remember, that arrest and subsequent transport to jail is not part of the punishment. It is in order to secure the defendant's appearance at a court at a later date. The first time the defendant sees a judge, most likely within 24 to 48 hours after arrest, the judge will probably assign a bail amount. Bail is the security to ensure the defendant appears at court. The judge will also require a bond. The bond is the promise the defendant makes to return to court. This might be sort of confusing because, as we've previously mentioned elsewhere, the terms bail and bond are typically used interchangeably. The bond is like an agreement between the defendant and the judge. The defendant essentially says, I understand that in order to be out on bail while I wait for my case to proceed through the system, I have to promise to appear at court. In addition, the judge will mandate the defendant make other promises as a condition of him being able to remain out and not sit in jail waiting for his case to come up. These will generally be the same or similar conditions that might be found in a protective order, such as not to go to the victim's house, not to communicate with the victim, and not to commit another criminal offense against the victim. If the defendant does anything the judge tells him not to do, then he has not only violated the conditions of his bond, but he has also committed another criminal offense. So, under the offense of violation of certain court orders or conditions of bond in a family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case, a person commits an offense if they commit family violence, sex assault, aggravated sex assault, or stalking against the protected person, or communicate directly or indirectly with a protected individual or member of the family or household except through an attorney in a threatening or harassing manner, or if they go to or near the residence, place of employment of the individual protected, or any child care facility, school, or residence of a protected child. If they possess a firearm, harm, threaten, or interfere with a protected pet, or finally, tamper with the normal function of a GPS monitor required to be worn by an order. The Penal Code specifies that reconciliatory actions or agreements are moot, which means irrelevant. In other words, it does not matter if the victim agreed or allowed the conduct. A protective order is a judge's order, and no one can change it except the judge. So, for instance, let's say a peace officer does a traffic stop. He finds a man and a woman in a car. He determines the man was arrested for family violence against the same woman a few days ago and is out on bond. In other words, he made his bail and agreed with the judge he would return to court. The peace officer finds out from the dispatcher the man is violating the conditions of his bond by being in the car with the woman. Upon speaking with the man, the officer finds out the woman invited him to go for a drive to talk and work on their relationship. The woman tells the officer the same thing. Even though the victim in the case consented to the defendant being near her, the Penal Code states reconciliatory actions or agreements are moot. Since the man has violated his agreement with the judge, he has committed an additional criminal offense no matter what the actions of the victim were. It would be the same if it was a protective order instead of conditions of bond. A protective order is issued by a judge. No one, not the defendant, peace officer, or even the victim can change it. Only the judge can adjust, modify, or vacate the order. The Penal Code goes on to make a very, very important mandate. The person protected by the order cannot be arrested for violation of the order. So in our previous example, even though the victim of the previous family violence offense may have actually consented to the defendant being with her, which was a violation of the judge's conditions of bond, she should not be arrested and cannot be arrested for this offense. The level of penalties for violation of certain court orders or conditions of bond in a family violence, child abuse or neglect, sexual assault or abuse, stalking, or trafficking case are a bit complicated. If a person commits this offense and has 2 or more convictions for the same offense, it is a felony of the 3rd degree. If a person commits this offense and has 2 or more convictions of the separate offense of repeated violation of certain court orders or conditions of bond in a family violence, child abuse or neglect, sexual assault or abuse, stalking, or trafficking case, the commission of this offense is a felony of the 3rd degree. A person who commits this offense and has a conviction of this same offense and also has a conviction under repeated violation of a court order or conditions of bond is also a felony of the 3rd degree. A person who commits this offense by assaulting the victim or by stalking the victim enhances the offense to a felony of the 3rd degree. A person who violates an order related to certain offenses under Section 7A of the CCP has committed a state jail felony. All other offenses are A misdemeanors. Finally, the Penal Code specifies it is not a defense. The pertinent information was excluded from the order. There are several laws in the Texas Penal Code which might make you wonder out loud, is this really a problem, or do we really need a law for this? The answer is, unfortunately, yes. We'll talk about 2 offenses which deal with selling or purchasing a child or advertising to do the same in this screencast. The first offense is sale or purchase of a child. The Penal Code states a person who possesses a child younger than 18 commits this offense when he or she offers to accept, agrees to accept, or accepts a thing of value for the delivery of the child, or offers to give, agrees to give, or gives a thing of value for a child for the purpose of adoption. Just to clarify, we're not talking about legitimate and legal adoption agencies here. We're talking about pretty horrible offenses where someone in possession of a child sells them outside of what are otherwise legal channels. According to the Penal Code, it is an exception to the application if the fee is paid to a child placing agency authorized by law. For attorneys, social workers, mental health professionals, or physicians, for reimbursement of legal or medical expenses, or a necessary pregnancy-related expense. In other words, the statute doesn't apply to legitimate and legal adoptions. If the person buying or selling the child does so with intent to commit the Penal Code offenses of sexual performance of a child, trafficking of persons, solicitation of prostitution, or compelling prostitution, the offense of sale or purchase of a child is a felony of the 2nd degree. All other offenses are felonies of the 3rd degree. The next offense is the related offense of advertising for placement of a child. A person who advertises in the public media or over the internet for sale of a child commits this offense. As in the previous statute, This offense does not apply to a licensed, legal, and legitimate child placing agency. A person who commits this offense with a previous conviction commits a felony of the third degree. All other offenses are A misdemeanors.